Hello?
Hi, Mr. Whitlock?
Yes, it is.
Okay, Ms. Chandler is here.
Hello?
We're ready to go. But I appreciate you all being available in such short notice. Let me tell you why I called to speak with you. Initially, I called because there was still one vote in dispute. I'm ready to issue the order. As a matter of fact, we thought we could issue it today, but we could not. And that was the ballot cast by the Mary Boyle Trust. And rather than send out an order, I was going to bring you together and ask you to produce certain records with regard to Mary Boyle's trust. After that, I began to research the issue on my own, and I determined that I no longer needed to do that because this is what I found. Mr. Whitlock, although you have Patricia Kerr in an affidavit stating that she indeed has the power or a power of attorney
Yes.
for the Boyd Trust, that is not sufficient proof, and if this were to be upheld, I would have to see a copy of the original power of attorney. There's more to it than that. Your burden in order to sustain your position that it should be counted would also require you to prove that the association was on notice of the power of attorney no later than the meeting called on December 2nd to consider the recall. Presenting that now, even if you had a power of attorney you could copy and send to me, is too late to sustain her vote on the ballot. You cannot wait until after the association has made a decision about whether to certify or not to bring forth proof that Patricia Kerr is indeed the holder of a power of attorney. These laws are pretty clear about that, and it makes sense to me. The association has to be on notice about it before you can charge it against them, and they have to know about it before they actually make the final certification question. Any questions, Mr. Whitlock?
No, ma'am. I thought the burden of proof, since they are the ones that challenged the ballot, they had the burden of proof to prove that she was not authorized by the owner to sign that ballot.
Well, the burden of proof to go forward with it, the ballot itself goes forward with it. They have presented their proof, and that is that the ballot is definitely signed by someone other than Mary Boyd or a trustee. All it has on it is POA. That is insufficient. The POA, a copy of it must accompany the ballot when the recall agreement is served on the association, or no later than before the meeting to certify it. Their burden is sufficient if on the face of the ballot what they say appears to be true.
Okay.
And there is no connection. You understand that?
Yes, I do.
Okay. That was primarily what I wanted. And what I was going to do earlier before I finished looking at the case law on this was simply ask one of the other or both of you to produce a copy of the power of attorney. And once I found the case law, it was clear it doesn't matter whether you do or not. It was too late to produce that as proof that her ballot should have been counted.
What about the voting certificate that was on file with the association?
Well, I don't have it. And if there was a voting certificate on file that also had to, just like the power of attorney, that has to be included with the ballots when they were served on November 25th, or at the latest, no later than the meeting calls to. Not during the meeting, not at the meeting, not at the tail end.
Right.
But, yeah, before the meeting. Anything that allows someone other than a title record holder to cast a ballot must accompany the ballot.
I understand. In this particular case, the respondents were not the custodian of that record, so it was impossible for us to have that record attached to the ballots.
Okay, well, you got to sign an affidavit. If she had a copy of the POA, she should have given it to you.
Okay.
Right? If she signed it as the POA, she should have given it to you the day she signed it, whenever that was.
Okay. All right, I understand that. Okay.
All right. Is that clear enough for you? Anything to say, Ms. Chandler?
No, ma'am.
Okay, great. Let me see. There was one other. Also, while I'm here, I'm not going to disclose anything else except just to say, Mr. Whitlock, and I'm not here to entertain arguments to the contrary. You cannot bring any ballots after the service date, valid or not, okay, that can then be counted. The law nor the previous case law in that area allow that. And I noticed from your pleading that you continued to allege that those ballots were valid, and they may be for another election. You know, those ballots, homeowners associations are good for 120 days, but it is no good having brought them after the service of the recall agreement.
You're talking about the 2 or 3 additional ballots that we tried to file on the...
Yeah.
I understand that, and that's why in my memorandum I dropped that issue of those 3 ballots.
Now, in the 3 or 2, because I'm telling you, my supervisor and I couldn't figure out, we didn't know whether it was 3, whether it was 2, and we both read through it, and I said, I don't know which one it is.
But I withdrew that, Your Honor. I dropped those additional because I read the case law as well, and I understood they had to have been presented when the others were served on 11/25. They had to be served on 11/25, not on December the 2nd. So my calculations do not factor them into the column. I'm only addressing the 27 disqualified ballots.
And I will tell you one other thing, both of you. It took hours and hours and hours. But, we had to decipher the aging report and all of that. I will have to say, Ms. Chandler, and if you think this is incorrect, either one of you may challenge it in a petition for rehearing. But we found in the count that
Okay, I don't have, I apologize, I don't have the file in front of me, and actually this is my first day back in the office as my mother passed away over the weekend.
I'm so sorry.
Thank you.
I'm so sorry. Have you been ill?
Off and on a couple times, but it was somewhat unexpected, so.
Oh my goodness, I'm really, really sorry.
Oh, thank you so much. Thank you. So I know that we did that count again, so I will certainly go back through my notes and, make sure that that's the case, but that's...
And
Madam,
if not, and if you want a little bit more time, I think you can file a request for longer, a smidgen longer than 15 days to do the motion for rehearing. I let me lie on that because I haven't looked at the rules that closely. And I've done it once, but it wasn't challenged, so I don't know if that was okay or not. But it was an amazing chore to go through all of that. And Ms. Jones, the next time any of this happens, please make the decision writing the minutes for the meeting to consider the ballot. Please put the names next to the addresses.
Okay.
It was
Certainly will.
a horror. But that's what,
I think oftentimes they try to leave the names out because they try at least when they're suspending the rights not to further embarrass people by pointing them out by name.
but you know what? But you know what? Anybody wants to do it and find out the address and whatnot, they can go find them anyway. And it's really problematic. It is really, and I know exactly what you're doing. Some people don't name them or they still name them, but we end up unsealing them because we simply can't, do that. But I understand what the strength of it is. I knew exactly why you had done it. But it was a horror. And I don't know how many people you all had on the ballot that night, but it was just me until yesterday. I said, help! And my supervisor's a math major, and it still took him a couple of hours. So we think we're right where we need to be right now. The last subtraction we did ended up right on key. So this order will be issued Monday. Okay, no later than Tuesday. But I'm ready to issue it, but I'm not ready to stay here another 2 hours to do it with all I've got 18 files backed up here. And I'm only exaggerating by probably 5 or 6 that I have not been able to get to. But I wanted to let you all know what was going on, and I really appreciate your being so amenable to talking with me.
Oh, thank you. Very welcome.
our pleasure.
Back on testing, I know that after we had our last meeting and there was a discussion about not filing anything supplemental without a request, I know that Mr. Whitlock did go ahead and submit some clarifying information or something. Was that additional information taken into account? Because if it was, then I think that we should have, we should have had an opportunity to respond to it. But with the death of my mother, it kind of, everything got a little pushed back. So I wasn't really.
I am inclined to say no, I did not, because when I realized that the wording of my first order gave Mr. Whitlock, and you can't give Mr. Whitlock. Mr. Whitlock is very, very sharp.
Thank you.
Very smart.
Thank you.
And I gave him leeway, and he did not violate that. He did not file anything in response to that order. Right. So I do not recall that I even looked at it once I saw my mistake in wording of that order. Mr. Whitlock's pretty sharp. I don't know how he does this in the middle of the night.
Thank you.
I know you can hear us talking about you, Mr. Whitlock.
Thank you. Thank you very much.
It's complimentary.
Thank you. It's very hard work.
Actually, I don't even know what it is, but because I have a son that's pretty tenacious like that, and so I family?
Yes, I believe that. Tia emailed me, so I believe so.
Well, then she has it then. I got you. And what we'll do is probably try to email it, depending on how Tia feels at that particular moment.
Okay.
Right. Thanks.
Okay, thank you.
Thank you, ma'am.
You're welcome.
Have a good weekend.
You too. Bye-bye.
Bye-bye.